Hi there, I'm Christian Reinders, Chief IP Counsel of the Dräxlmaier Group, and you are listening to IP Fridays.
Hello and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
Welcome to episode 116 of IP Fridays. Today's interview guest is Christian Reinders, Chief IP Counsel of the Dräxlmaier Group, a larger automotive supplier, and you will be surprised what you can learn in today's interview. Before we jump into the interview, I have some news for you. The Administrative Council of the European Patent Office has decided that evidence can now be taken by video conference. So, for example, witnesses can now be heard in oral proceedings via video conference. And I also stumbled over a very interesting report of the EU IPO, the EU Intellectual Property Office, titled Trends in Trade in Counterfeit and Pirated Goods. From this report, we learn that still about 80% of all customs seizures, by the number of seizures, for counterfeit goods come from China or Hong Kong. The next largest source of counterfeit goods is Turkey with about 6%, and all other countries of origin are about 3 or less % by the number of customs seizures. The overall value of all fake products imported into the EU were about 121 billion euros in 2016, which is about 134 billion US dollars, and that makes up about 6.8% of all EU imports, so quite a significant number. The main origins of fakes coming into the EU are China and Hong Kong, and then United Arab Emirates and Turkey. So now let's jump into the interview with Christian Reinders. Today's interview guest is Christian Reinders. He is currently serving as Chief IP Counsel of Dräxlmaier Group, an automotive supplier with 75,000 employees worldwide, so one of the larger ones. And he has an interesting career. He has been in-house and in private practice, so he knows both sides of the story, basically. And he's also teaching young IP professionals and is currently he's member of the EQE examination committee. So he is looking after all the young European patent attorneys. Thank you for being on the show.
Thank you very much, Rolf. It's a pleasure, and thank you very much for the invitation. It's very much appreciated. Thank you.
Yes, we have a couple of very interesting topics, very diverse topics today. And let's start with one fundamental basic question. When we talked earlier last week, the most important question for you and where it all boils down to is why? We both know the famous TED Talk of Simon Sinek, but I'm not clear how this can really apply to IP, to intellectual property.
Thank you very much for your question. The overall topic, I think, of this podcast is about strategy, and especially the question, why are you doing what you are doing, or more precisely, what should you doing? And this is really something which resonates, I think, with why of Simon Sinek, that we as human beings are always inspired by a sense of purpose and what are we doing? And this is, for me, let's say, one of the really basic questions also in the patent world. At least for me, it has two aspects. The first aspect is basically for myself. So, I know it might sound a little bit selfish, but we all want to know why we are going to work and what we are doing, and we all want to have a good feeling if we drive home from work. So that's the first aspect. But the second one, I think, is also very, very important, because only if you understand why are you doing things, you also can convince and talk with other people, especially if you're working in-house with other departments or with your clients and so on. And this really is from my perspective, one of the main important questions if you're especially interested in strategy. For example, you find in a lot of companies so-called KPIs, key performance indicators. Very often it is the number of invention disclosures within a year or the number of patent filings. But if you really ask the question, how does it help to progress within the company? How does it really help this kind of number for the company? You might end up with the question, why is it? And then very often you don't get any answer because it is very often mentioned, these are numbers defined years, maybe decades ago, and everybody's just following these numbers. And so I think on one hand, it's very, very important to just keep in mind, you have to monitor and track your work, and then this is again the question, why is really the number of invention disclosures, is really the number of patent filings in a year, or maybe 10% more than compared to the last year, really one indicator which helps you with your why. For example, I think, and that was luckily confirmed also by the board of management at Dräxlmaier, when I started, I questioned this kind of indicators and asked, do they really support your different various business models in different technology segments? And interestingly, the room felt completely silent. For me, it was really this, okay, so are these kind of KPIs really what we need? And then, it's really going forward from that and then trying to find what are the KPIs or what kind of patent portfolio do you need in the future? So this is, for me, one of the aspects. And then the other one, again, I think if you find your why, you can convince and take other people, especially other departments, on board and ask them, okay, do you support this? Do you understand that? Again, just a minor question from my present work. So again, when I started, I asked, are these filing numbers, are these numbers of invention disclosures really helpful for the company? And it became very, very quickly clear that these are probably just in this kind of general aspects, probably not. And as a consequence, at Dräxlmaier, we don't have these traditional KPIs like number of patent filings or number of invention disclosures received within a year. Instead, I agreed with my management targets like number of FTOs, so freedom to operate searches, the rate of grant of patents versus the number of filings, and also some kind of internal, I would call it custom feedback. So various in particular development departments, but also sales departments are asked how satisfied are they with the work of the patent department. So these are now, let's say, KPIs I defined with the board of management. And what is also important to keep in mind that I prepared and explained this why also to other departments, especially, for example, to the financial department. I think one of the really underestimated departments you need to try to take on board if you work in a patent department, because, for example, what happened if these KPIs, number of invention disclosures and number of patent filings were dropped, is that we experienced a significant drop in the number of invention disclosures and patent filings. The reason were obviously low quality and the normal incentive, just signing, just filing an invention disclosure, 3-sentence, a line. This is an invention disclosure. You get your incentive, and it's done, and it's a number, and everything was fine. And we, as mentioned, experienced a significant drop. More than 50% invention disclosures are less. We received now 50% less invention disclosures compared to, for example, 2016, but with a better quality, and also the number of patent filings is now on a level 2/3 compared to 2016. Now, why is also in this situation why important? Because I took the financial department on board, and they were aware that, okay, there is a drop in these numbers and so on. Then it was clear that they can't, let's say, chase me and say, okay, now you only get 50% of your budget, and happy day for you. So it was very, very important to explain also these steps to financial departments, in particular for this question, take them all on board. And this is, again, a very, very good point, really, to think seriously about your why.
Yes, your work becomes much more efficient this way. I had one idea. You were talking about the KPIs that are important, and I thought, can also be the oppositions that you receive from your competitors be a good KPI? So I think my thinking was that maybe your patent portfolio would be more interesting to your competition when they file more oppositions, or more dangerous for your competition, let's say.
I think it's a wonderful idea, and I tell you what, I exactly thought about this. Also, maybe thinking about defining this as a target for my patent attorneys. I think it might be a good measure for big patent portfolios. However, we only have a very small patent portfolio. It's around 1,100 patent families. And, thinking also about where could be the flaws of this KPI, I quickly came up with the idea, so what will I do if I get this target? And I just thought, okay, maybe I would ask some of my friends to file some straw man opposition to just raise a number of oppositions against my own patent. So, that was one idea. So I'm just kidding now. But, if you define this KPI, and that was, I think, for me, also one of the, let's say, harder experience. If you're thinking about new KPIs as an alternative to the traditional one, you have to really think deeply about what kind of KPI do you need, how do they assist your why, how do you help you to benchmark yourself, how to help you to monitor what you want to achieve with your patent portfolio.
Yes. I actually had an idea about the strawman idea, because when you litigate patents, you can be more successful as a plaintiff when the patent already survived opposition or revocation proceedings. So it might be an interesting idea to provoke basically oppositions. But yes, I didn't put this into life yet.
I could say no comments.
No comments, right. So I have a completely different question, and now to something completely different in the words of Monty Python. So you are also a member of the IP Commercialization Committee of the Chartered Institute of Patent Attorneys in the UK, and you lived in the UK for a while. Why? Your favorite question.
Coming back to, this question regarding why are traditional KPIs known in the business may be appropriate or maybe not appropriate. And for me, let's say the really, I wouldn't say frightening, but very concerning topic is, as soon as you question number of patent filings, the number of invention disclosures, you feel, or at least I felt, a little bit left like in the desert, because there's nothing around. So a lot of patent departments are run by KPIs like number of patent applications, and you drill it down to each patent attorney, and they have to do blah, 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 and so on. And if you ask yourself, does it really help the company, and does it really help you to build up a strategy or assisting the business model, you very quickly are in completely uncharted water, and especially these kind of committees, and also having this kind of access to the Anglo-American world, where patent portfolios sometimes also managed and optimized in a little bit different way than in Europe. It really helped me to, let's say, build up a small network where I can discuss with people. Does it make sense to focus on, for example, number of FTOs and so on? And I think that is really, really important, especially if you want to divert from a little bit traditional way and do things a little bit differently. You need for yourself this kind of confidence that you are on the right track, because don't forget, we are, let's say, dealing with very important assets for a company, and they are very important assets not only now, but especially with this time delay in 3-5 years time. It is granted, and if you make a mistake now, it maybe this has no impact immediately, but in 3 to 5 years time, it might have a very, very big negative impact on the company. And that's what I definitely want to avoid. So yes, this network is very, very important to have some kind of discussions, how to use things and so on. And that's basically the reason. And I loved London, I must admit.
Yes. And at CIPA, you are teaching young professionals about patent strategy, as you already mentioned. Maybe can you give our listeners like the most important takeaways that you try to communicate to your students there?
I think, and this resonates, I think, very well again with the initial question, why try to understand your company and your client. So every company is different, every client is different, it's different technologies, it's a different company structures. Sometimes you have this kind of silo structures where, for example, I actually work in the automotive industry, which means it is very traditional. There's an R&D department, there's a sales department, there's a procurement department, and so on. There is some kind of flow of information, but not very often. So each department is doing things maybe separately, maybe differently, and to understand that and to identify the stakeholder within the department who are maybe patent minded and maybe who are not patent minded is I think very, very important. And then also, for example, if you have this kind of silo structure, really to understand what kind of impact not only building up the own portfolio might have on your company. Another aspect I think is very often also slipped a little bit under the carpet is the risk of third-party patents, and also thinking about what kind of risk may have an impact on your company, not only on R&D, but in particular on sales. And again, if you have this kind of silo structure, how to teach and how to raise the IP awareness in departments which are maybe not so closely linked to R&D as, for example, we in a traditional way as patent attorneys have this very close links to. What we experience at the moment already is that especially during contract negotiations between us as a tier 1 supplier and the OEMs, these questions regarding have you searched for third-party patents and so on now crops up more and more. And at the moment, we experience a lot of demand from our sales department, interestingly, who came to us and say, we had this question regarding patent searches. We have done something. Do we need to do something, and so on? And this is now something, an issue, I think, where we have to look very closely into it. And that is also the reason why now we as a patent department are much more involved in contract negotiation and contract management than before, because all these questions also about background IP, foreground IP, licensing to OEMs and so on are very, very important. And so from my perspective, this is now at least, some kind of further support, let's say, for our idea to raising the IP awareness. And we also use this kind of questions very often then now for training. That's basically about that.
Do you think that this principle of standard essential patents can be also applied to other areas of technology, so not telecommunications or related technology areas, but maybe also production and manufacturing? And if yes, what challenges do you see there?
I think there's a really high potential in this kind of business model. And personally, I think in the future we will see maybe in various technology segments, even in one company, very different business IP business models. So maybe in one sector it's really standard essential patent licensing, and the other one is traditional one, and maybe the other one is just freedom to operate. So I think this really has an impact, especially also as a kind of general business model for companies. What we at the moment try, and this is definitely one of the challenges, try to maybe adapt this kind of model into other areas. So, for example, Dräxlmaier is involved in assembling this wire harnesses, so this 1 or 2 kilometer cable, which is placed into a car. And you have also various standards for this cable, like Ethernet and all these different standards in the cable industry. And we also have now some internal discussions about, okay, so what are the benefits maybe to joining this kind of standard, to contribute to the standard? And that is, I think, something we will see in the future also in various other aspects. Having said that, one really major obstacle and really challenge for this is obviously you need an infrastructure for that. So it doesn't really end up that you have 1 or 2 engineers sending them, let's say, once a year to a standard committee and saying, okay, we have this fine technology and coming back. So you need really this kind of infrastructure, this kind of flow of information about strategy, what happens in the standard committee, building up the patent portfolio, which is then mirrored again to all the other departments. And I think this is really, really the challenge. And especially, if you come from this, again, silo structure, very traditional company structure, where this flow of information between departments is, let's say, not so agile, let's say, as, for example, in a new software startup company. So I think this is something we will see. And I definitely think that one of the first companies who managed to implement this also maybe in other technical fields will have a significant advantage.
Yes, I think so. So be on the forefront, but you are, so that's good.
Again, so at the moment we are only discussing, so.
Yeah, of course. But it's a very interesting idea, I think, to have this principle applied to other technological fields, right? So finally, as my last topic, maybe the hottest topic, that becomes increasingly important, big data or data. So OEMs increasingly want to gather the data from their customers and ask you to help them, basically. So what is your take on this topic, use of data by the OEMs and you helping them to gather the data?
I think data is really one of the really underestimated IP topics at the moment, because you see 2, let's say, major drivers. One is an internal driver and one is an external driver. So as mentioned, the external driver is, especially if you read now the new contract draft from the OEMs, always data now crops up. It's all about, we want to have access to your data, and it's not only on what day a specific product was produced. No, it really goes very often now down to what was the temperature, what was the pressure of this specific product. So it will become, I think, a kind of liability and warranty issues in the future, because with this kind of data, you might drill down and identify, okay, something went wrong in the production, and you can maybe identify this very, very specifically. The internal driver, obviously, is quality and improving processes. So you might have heard about the concept digital twin, which is that you mirror every product you produce in a kind of software model, and then doing some kind of simulation and making a kind of forecast how the digital twin hopefully develops exactly like the analog twin. Plus, another, I think, very, very important issue is trainings data sets for AI models. So that is also something which I think is a little bit underestimated also during the discussion with AI, because I'm definitely not an expert, but if you speak to AI experts, they always mention that setting up an AI network itself, so how many layers, how many neurons, and so on, you can probably determine it very easily with a kind of algorithm, and it's used. And for me, this is basically still this kind of normal computer implemented algorithm, which should be technical enough, or course, according to the European case law, an additional technical effect. The same is for the learning algorithm, back propagation, forward propagation, and so on. And if you asked an AI expert, they normally mention the time I spent on designing and developing the network and thinking about the algorithm and implementing it. It's 20% of my time. 80% of my time I spent on generating the training data set, and so on, and so on, and so on, which is, from my perspective, interesting to think about, that probably with patent law at the moment, you only can protect 20% of the work, and 80% of the work is data, and nobody's looking in. Plus, but that's now a very, very personal opinion. If you have a very generic patent claim, just claiming method for, let's say, detecting number plates using an AI model, I sometimes ask myself, is this sufficiently disclosed?
Yes.
And so I think data and data, to be honest, already play an important role in chemical and especially pharmaceutical patent applications, and may be patent, but I'm not really an expert, are also relevant for this various patent topics, which might be very, very important also future business models for companies. But nevertheless, I think that especially we as patent attorneys with this background and legal and technology, we are very, very fit for purpose and can bring a lot to the table, also about these other topics like data or legal clearings of open source software or things like that.
Yeah, it will be very difficult, I'm looking forward to see successful patent applications in the AI field where the data sets are sufficiently disclosed. So it's really difficult because these data sets are huge, and probably it will end up like with the DNA patent applications, where you have to have a huge appendix with all the sequences of the DNA, and now you have huge appendices with the appendices with data sets. Let's see how the patent professionals solve this problem with sufficient disclosure in AI. Yes, this has been a really, really interesting and valuable interview, and I'm sure our guests profit a lot from listening. If our listeners still have questions for you, can they reach you somehow, or yes? What would be the best way to get in touch with you if they have questions?
If they have questions, you can find me on LinkedIn. definitely. And you can also drop me an email address, which is Christian, like the religion, Reinders, Raenders, at Dräxlmaier, which is DRAXLMAER.com.
Thank you so much. Thank you very much for being on the show.
It was a pleasure. Thank you very much for the invitation, and hopefully it was helpful for your listeners. Thank you very much.
I'm 100% sure. Thank you so much.
Thanks. Bye-bye.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.